Good evening, everyone, and welcome to the launch event for Volume 45, Issue 3 of the University of New South Wales Law Journal. On behalf of the Journal, I would like to begin tonight's proceedings by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather here this evening. We pay our respects to their elders past, present, and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us for this occasion. My name is Darius Dadgosta, and I am the Executive Editor of the University of New South Wales Law Journal. It is a privilege to welcome everyone here tonight at the Sydney office of King Wood Mallesons to the launch event for Volume 45, Issue 3 of the UNSW Law Journal, the journal's third in-person launch event this year. The UNSW Law Journal is very proud of its long-standing relationship with premier sponsor King Wood Mallesons, which since 1981 has been integral to the journal's development and present status as one of Australia's leading academic law reviews. The journal would not be the esteemed publication that it is today without the over 41 years of continuing support from King Wood Mallesons. I would like to thank in particular Miss Sarah Morrison and Miss Greta Trelaw for their assistance in helping organise tonight's launch event, and Miss Peter Stevenson, Dispute Resolution Partner at King Wood Mallesons, who will be speaking on behalf of the firm shortly. I would also like to thank the journal's other premier sponsors, Allens, Cause Chambers Westgarth, and Herbert Smith Freehills for their invaluable support. I would also like to thank Issue 45.3 of the UNSW Law Journal features 6 general articles that explore an array of independent topics and 5 thematic articles that examine a breadth of topics relating to law and economics. The thematic articles in this issue all convey the utility of economic reasoning in providing novel insights into and solutions to pressing socio-legal issues. I would like to thank all of the authors featured in Issue 45.3, some of whom are here this evening, for entrusting the UNSW Law Journal with their insightful scholarly works and contributing to legal discourse on issues of major significance. I would like to welcome and thank the Honourable Dr. Bennett, Annabelle Bennett, ACSC, former Justice of the Federal Court of Australia, for joining us this evening to deliver tonight's highly anticipated keynote address on law and economics. Congratulations are also in order for Catherine Cheng, the editor of Issue 45.3, for formulating such a timely thematic topic and working so tirelessly in coordinating the peer review and editing of the articles in this issue. Seeing an entire issue through to publication is an extraordinary achievement, one that requires innumerable hours of focused work, and the editorial board is very proud of how Catherine has worked throughout this process with such conscientiousness and proficiency. I would also like to take this opportunity to thank the rest of the editorial board for their many hours of diligent editing, without which the UNSW Law Journal would not remain the respected publication that it is today. Last but not least, I would like to thank the UNSW Faculty of Law and Justice, particularly the faculty's Dean, Professor Andrew Lynch, and the journal's faculty advisors, Professors Gary Edmond and Rosalind Dixon, for their unwavering support of the journal and editorial board. I would also like to thank Associate Professor Wei Huan Zhou, Director of Research at the UNSW Faculty of Law and Justice, who will be delivering a vote of thanks later this evening. It is now my pleasure to invite Ms. Peter Stevenson, Dispute Resolution Partner at King Wood Mallesons, who specialises in competition litigation, to speak on behalf of King Wood Mallesons. Thank you, Peter.
Thanks, everyone, and welcome to King Wood Mallesons. It's wonderful to have you here in person after a 3-year hiatus. I join Darius in acknowledging the traditional owners of the land on which we meet, and we at KWM accept the invitation in the Uluru Statement from the Heart to work together for a better future. I'm very proud to be here standing on behalf of the firm to launch this issue of the Law Journal, given the long-standing relationship between the firm and the law school at UNSW. This relationship has many aspects, including with the Law Society, with Dean Andrew Lynch, Ros Dixon, and other members of the faculty. And we're particularly pleased that we'll be welcoming 10 UNSW students to KWM for their clerkship this summer. But I'm particularly proud, as Darius mentioned, of the relationship that we have with the journal itself, which this year marks a 41-year relationship. only slightly longer than the term of the longest-serving partner at KWM at the moment. But as a competition lawyer, I am very excited to be launching this particular issue, Volume 45, Issue 3 on Law and Economics. When I started my legal career at the end of last century, I was desperate to be a litigator, but a very kindly partner suggested that my degree in economics could be put to very good use in analysing and applying competition law to problems, policy and commercial matters. And I'm very thankful that I listened to that partner, UNSW alumni and now Justice Trish Henry of the Supreme Court, because the intersection of law and economics has delivered a richness to my life and my career that I could not have imagined at that time. As editor Catherine Cheng notes, it's impossible to deny the indelible touch that economics has left on public policy, noting in particular the government's new nudge unit within the Treasury. This includes influence in the competition law space. And in fact, ACCC Chair Gina Cass-Gottlieb noted just earlier this month that the ACCC has developed an in-house behavioural economics capability to assist it in navigating cases involving consumer-facing markets. And we are all now very clearly on notice that the views of these economists will be taken into account in developing theories of harm and preparing evidence in ACCC enforcement action. And so this issue of the Law Journal will be essential reading for my team of competition lawyers, as I hope it will be for all of you. In its pages, there are 5 thematic chapters dealing with a very broad range of topics. I congratulate the entire UNSW Law Journal editorial board for drawing together these thematic articles, as well as the articles in the general section, which I also look forward to delving into. Particular congratulations go to Catherine Cheng, editor of this issue, whose mum Carol is here with us tonight, and I invite her to come forward and speak to you. Thank you.
Thank you, Peter, and good evening, everyone. My name is Catherine Cheng, and I am incredibly excited to introduce issue 45.3 of the UNSW Law Journal as its issue editor. I would also like to begin by acknowledging the traditional owners of this land, the Gadigal people of the Eora Nation, on whose land we gather tonight, and pay my respects to elders, past, present, and emerging. I extend that respect to all First Nations people with us tonight and acknowledge that this land was never terra nullius. The land belonged to these people, was never ceded, given up, bought, or sold. It was and always will be Aboriginal land. So, to introduce the theme of this launch, law and economics, I must begin with an anecdote. Just over a year ago, I attended a class taught by our very own faculty advisor, Rosalind Dixon, called An Economic Analysis of Law. And I must confess, it wasn't for very intellectually admirable motives, essentially. The class appealed to me for 3 main reasons. First, it was an intensive class which ran for 4 weeks, which means I would have the latter half of the term to prepare for the Wells University Debating Championships. The second was the exam was due on the very last day of the exam period, which meant I could take the course, forget about it, and do the exam after the completion of the Wells University Debating Championships. And third, I'd recently grown really sick of losing debates in economics and not understanding what Pareto efficiency was, asset price bubble, or deadweight loss. And as a result, I hope that this course will fill this gap to a reasonable extent so I could find success in subsequent tournaments. So it is therefore almost a cliche to say that this course very much changed the way I view the world, and it was this class which inspired the conception of this thematic. So why law and economics? And after all, this is a field which has flourished in the United States, but has never really gained traction in Australia. The reasons aren't entirely clear. Perhaps legal academia got chilled out after Sir Anthony Mason had serious misgivings towards the value of economic analysis to the law, although I do hope such misgivings were assuaged after penning a wonderful foreword for this issue, and I'm incredibly honoured for someone of such eminence to have provided such insightful thoughts about the articles. Other reasons could simply be the fact that economics is quite overrated in what it seeks to achieve. As John Kenneth Galbraith mused, the only function of economic forecasting is to make astrology look respectable. And my co-star actually said today that you should avoid making public speeches, and it is good to see the universe has not collapsed after this demonstration of intransigence. Nevertheless, despite my poor attempts at a funny joke, one cannot One cannot deny the influence economics has on public policy. Economists influence the way children are cared for, the way countries regulate industry, and the way citizens are housed and nursed. And economic analyses are simply crucial to the way we understand the world. And I think in the process of this kind of body of scholarship blossoming, economics has developed empirically sound methodologies such as statistics and econometrics, and mathematically precise theory such as price and game theory to provide quantitative assessments which often reveal shocking or counterintuitive things about the world. John Donahue and Stephen Levitt of Freakonomics fame identify a strong effect between legalised abortion and a reduction in crime rates, which only becomes more significant after the overruling of Roe v. Wade earlier this year. In another statistical study, of more than 1,100 judicial rulings in Israel, prisoners were granted parole at about a 60% rate when judges have recently eaten, and at essentially a 0% rate just before judges ate. So, justice may be blind, but she's sure sensitive to her stomach gurgling. So, to the 10 authors who penned the 5 articles of the thematic edition, they have produced some truly incisive scholarship. From questioning the primacy of laws in arranging social order, to identifying agenda effects that leave women worse off in patent applications, to drawing on insights from behavioural economics to posit strategies to reduce humanity's meat consumption, to critiquing law and economics' focus on efficiency in relation to taxation laws, and to identifying the very real possibility of bias among certain judges when it comes to the judicial review of refugee cases. I hope for all of you who have picked up a nifty volume of issue 45.3, you find something of interest that demonstrates the relevancy of economic analyses to the law. I am also incredibly proud and lucky to be able to publish 6 fantastic journal articles, with many articles also adopting an interdisciplinary approach drawing upon techniques from scientific disciplines. I've considered this issue to be the equivalent of an alt-rock indie album, a little bit different, somewhat edgy, but all in all, very interesting. And I must extend the warmest thank you to all the authors who have entrusted me with their articles, and it has been the greatest delight working with you all. Now we reach the difficult part of this address. For those who know me, my modus operandi is typically one of bravado and bluster, so demonstrations of emotional sincerity are quite rare. Especially in such a public forum, I can't help but feel like Cordelia in King Lear when she's compelled to express her love for her father, and she says, "I cannot heave my heart into my mouth." But formality in this circumstance dictates something must be said, so as a precursor, know that what I will say is only a fraction of what I actually feel. So for those who are unprepared and who are unused to such, I think, emotional honesty, I can see some of you in the corner over there squirming already. There is an old piece of Chinese wisdom which says there are 2 cringeworthy phrases in one's life that must be repeated no matter what. Thank you and I'm sorry, and I think these are phrases which will be repeated a lot in this part of the address. So first, thank you to our wonderful boardies. Your Herculean efforts were the backbone of this issue. Your meticulous attention to detail, the hours spent on legal research, and the ruthless deletion of every superfluous comma met the journal's exacting standards. More importantly, I must thank you for your friendship. The good chats shared over journal-sponsored gourmet sandwiches, fruitful debates about the use of the Oxford comma, and also every time Anna Ho would reply to one of my emails correcting my silly typos. Thank you very much for the good times. So, yeah. And your friendship really did make this whole experience, very, very great. So now, thank you also to the UNSW Faculty of Law and Justice and Dean Andrew Lynch for your ongoing support for the journal. Thank you especially for Dr. Wei Huan Zhou for attending as the faculty representative, and thank you for being here. Thank you also to our faculty advisors, Gary Edmonds and Rosalind Dixon. Your guidance and counsel turned all mountains back into molehills. Special thanks, of course, must go to Ros. After all, it was your class on a wintry Wednesday morning that inspired the theme of this issue. I'd also like to thank King Wood Mallesons for not only hosting the launch event of issue 45.3, but also for the mentorship and support I've received from my colleagues at the firm over the past few months. Seeing my supervising partner, Maureen Seville, and a senior associate from our team, Nicholas Andrews, here has been particularly heartwarming. I must also thank Sarah, Kelly, and Greta for your tireless work in making this event possible. I also must thank our other premier sponsors, Allens and Linklaters, Herbert Smith Freehills, and Cause Chamber Westgarth for their continual support of the journal. Thank you must also be said to Kerry, our typesetter, John, our cover designer, and Thomas, our artist, because none of this could have happened without you as well. And now for the emotional part of the speech, and apologies in advance for the immense amount of cringe I will now post. To the executive committee, I am so glad I have some people who are not debaters I can call my friend. Despite the gradually declining schedule and decreasing class participation marks as I edited away in many of my waking hours, I think of these days as long smears of honey. Things I remember are the smell of George's freshly baked sourdough lathered in butter, the fact that every time I go to our cosy little office, there is always someone there so we can have a brief and cheeky gossip section, and subsequently get told off by the other faculty members for laughing too loudly. And the frequent reminders to stop speaking like a 14-year-old boy on Fortnite, where if something good happens, it's bass, and if something bad happens, it's scuffed. So apologies, and if anything, my only regret is not being able to get the terms poggers, goated, and tilted to stick in journal lexicon. Thank you to our executive editors, Darius the Godstar and Tina Wu, for your fearless leader and calm competence. To our 2021 forum editor, Arnie Sivakuba, and digital editor, Caitlin Gautama, thank you for being here when I was just taking my first baby steps as an issue editor. Thank you also to 2022 forum editor Isabel Wainwright for your reminders to speak proper English. I'm glad you've learnt what F in the chat now means. Thank you to the motley crew of issue editors, Georgia Finkbrigg, Akriti Shori, Kari Mayman, Enrico Minus, Hayden Cliff, and Alicia Mathias for being the warmest, funniest, and most capable people I know. I had truly the most base time working with you all. In particular, I must thank our 2022 digital editor, Callum Brunton, a friendship that has started from 8 a.m. pancake breakfast before Latin American history classes, and a not infrequent skipping of Japanese history classes. This has been a friendship that's continued over 4 years. Oh wait, just to clarify, since my mum is in the audience, I have not in fact been skipping any tutorials or classes. I retract that statement. But thank you for always being there, Cal, and whenever I need to commiserate about the most minor of inconveniences, for having back and always being up for a good yarn. And now to my friends who are here tonight, I must first make an apology. Sorry for being a massive flake this year. The journal, as many of you know from my prominent eye bags and slightly deranged murmurings about the AGLC4, is a lifestyle. But so the record is on paper. To the debaters here, I have not been using the journal as an excuse to flake on debating events. And to my friends on the executive committee, I've not been using debating events to flake on journal events, and in particular executive meetings, which I've always attended as well. But to those who have known me since high school, since I was 12 years old, I have in fact been using journal events to skip out on your mediocre Marvel movie nights. But I promise, after today, you'll probably see me more when you pick a better movie to watch in the theatres. Specifically, I'd like to thank Marin Cowell, David Wu, James Manton Hall, Eugene Backer, Jackie Chai, Jeremiah Edikbami, Matt Toomey, and Mark Rothery. Affectionately described as the fellas, it is your companionship which got me through these hard times. From Mark and Marin's never-ending folder of funny memes and tweets to Jackie's horrifically unfunny bits, which are still somehow somewhat charming. From Jeremiah and Tombstone's sparkling conversation starters and insistence we must get dinner, and Eugene's nondescript expressions of comfort, such as when I would send him 6 voice messages about some problem which came up, and he would reply with, rough. That was all I'd get. From James's comforting green active now button at 2 a.m, signalling our late night solidarity as we're both up late, working as you do at 2 a.m. in the morning, to David's less comforting green active now button at 2 a.m, which says, I'm still not playing League of Legends, but down to have a chat when my next game ends. You guys mean the world to me. A special shout out must also go to Aaron Torney-Yaden, whose economics wizardry and tutelage has improved my statistical and economics literacy, such that the conception of the thematic was possible. Now finally, to my family. Mum, I also must owe you an apology first. Sorry for being the most obnoxious daughter. The last time I gave a speech, I made fun of you in front of a hall of historians for strongly discouraging me from pursuing a history degree. You have understandably still not forgiven me for it, and have in fact on numerous occasions prior to this speech reminded me not to make fun of you again. So tonight, I must thank you instead for encouraging me to persevere with my law degree, which is what allowed me to become the proud editor of issue 45.3. So thank you, Mum, for forcing me to do this. I ultimately do not regret it, and I'm incredibly grateful and appreciative. And to my younger sister, Christina, the person in this room who probably had to make the biggest sacrifice to be here tonight, thank you for graciously sparing 3 hours in your otherwise busy schedule preparing for the HSC to be here. I appreciate it immensely. And by the way, in classic sisterly rivalries, this is the only nice thing I'll say to you for the next 6 months, so treasure it dearly. Now, to conclude this address, I have struggled with what I was going to say. I considered quoting Shakespeare again, or maybe finishing with good old "I am proud to affirm," but both are without doubt ill-suited for the occasion. I have no quaint adage or cheesy hype-up line about overcoming hardship, so instead I'll say one last thank you to my cat, Xiaoju. You are adorably menacing, and I'm sorry you couldn't be here tonight. But now, without much further ado, I would like to welcome Dr. Annabelle Bennett to deliver her keynote address. Dr. Annabelle Bennett is a former justice at the Federal Court of Australia. She is currently the chair of the World Intellectual Property Advisory Group of Judges, chair of the Australian Nuclear Science and Technology Board, member and former president of the Chief Executive Women, and director of the Garvan Institute of Medical Research. So if possible, could we please have a warm round of applause for Dr. Annabelle Bennett?
I don't normally stand behind a lectern because I find I can't usually see over the top of them and I can't get this microphone to go down. Yes, it does a bit. That's great. This was the most scary thing that I've done in a long time because, Catherine wrote to me and said, would I do this? And I sort of thought, no. No, because I say no whenever any work is involved. And I thought, this is something I can't wing. And no, because I looked at the topic and I said to her, you do understand that I do not know anything about economics. And she said, yeah, that's okay. And I thought, well, no, it's not. And it's been reinforced because I've been sitting here tonight listening to expressions being used and rolled off people's tongues that don't even have a meaning to me. They could be in Sanskrit as far as I'm concerned. And actually it reminds me, I hadn't thought about this, but it does remind me of when I was duty judge very early in my career on the Federal Court. And someone who should be nameless, but I've never forgotten exactly who it was, who now sits on the Court of Appeal in the State Court, came along and said, Your Honour, this is a case about SLC. And I sat on the bench and I thought to myself, I have no idea what he's talking about. And I thought, better to ask. I always think it's better to ask and make a fool of yourself initially than not ask and make a fool of yourself even more later on. So I looked down and I said, well, what is SLC? And with an eye roll and a bit of a sort of like this, which of course was very embarrassing for me, he said, it's substantial lessening of competition. And I thought to myself, what I immediately wanted to say to him as an intellectual property lawyer was, well, I bet you don't know what CGK is. Who knows what CGK is? Who's done IP? Nobody. Common general knowledge. How can you not know that? Everyone knows what CGK is. No one knows what SLC is. And I never forgot it. And it was the most awful thing. And I thought to myself, how embarrassing was that? But it goes to show that it's a dreaded hatred of acronyms. And acronyms are everywhere. And the one thing, if I can talk to you about how I've come around to this and where I'm going now, I did science, and that's kind of back to the patent work. I did science originally, and I did a biological science, and I did a PhD in what is now called cell biology. And then I decided to do a PhD. After I did the science, I did the PhD. And every year I thought, I'll go and do law. And my father had talked me out of doing law because in those days it was too difficult for women, he thought. And he was probably right. I got admitted to the bar. I was only the 33rd woman who'd ever been admitted to the New South Wales bar. Yeah, thank you. That just means I'm very old. But anyway, when I said I was going, when I went afterwards and I then did the law degree, and I'll come back to that in a sec, what was interesting to me was people said to me, you've just wasted 8 years in science. You've just wasted 8 years of your life because there is no way that anything you've done in science will have any impact in law. And people just say to me, how can you do both of them? They think differently. Now, I would have thought logic is logic, analysis is analysis, but people were convinced that a person who'd done science couldn't be a lawyer because the two somehow don't meet. And that's actually quite interesting. And it's true that for the first years at the bar, no one knew I had a science degree because you weren't allowed to use the doctorate then. It was sort of not done, except in Melbourne, where they all did it if they had one, but not many did. Anyway, so eventually someone read something about something in a magazine article and saw that I had a science degree and briefed me for my first patent case. And that was the beginning of the change of my professional career. But what it taught me was that, nothing is wasted. No knowledge that you ever come across is ever wasted. You think it is. You do these things and you think, I'll never use those again, and then something comes up and you're the only person who's got that particular combination, and it works. And so 2 things come out of that. The first is never pretend to know what you don't know, but don't, and I'll come back to that too. But also, it also is very helpful to have done all these other things that you do and you bring them together. And actually, while the speech was being given, I was thinking, earlier I was thinking I'd never done anything about economics and the law, and I thought to myself, well, actually I have. And I did one of the biggest competition cases that was ever run in the federal court in Australia. It was a case that ran for over 200 hearing days. I bet none of you know what it was. It was called Apple versus Samsung. And it settled 6 months after I'd reserved, and I'd just finished writing it, and they didn't even tell me they'd settled. They filed in the registry because they were worried that I might publish my reasons. If they told me, I might have come out and said, if you think I'm going to do away with this, I've got this great big pile of judgment here, I'm not going to do it. And so they did that and it didn't happen. But I had to decide between experts in economics for a person who didn't have any knowledge of it at all. And it's very interesting how important it is when you really do know things, don't talk in acronyms and do not talk down to people, especially if the person is a judge. SLC, never forgotten. They, like when that case came back, we were very lucky that barrister had moved on. But so what I'm just trying to get at, and don't forget that every bit of knowledge you have is good. And some of that I'm going to bring in as I talk about some of these articles, because I actually sat down and read. I read pretty well all of them. It was actually quite an extraordinary experience. I started off thinking, I'm not going to understand any of this, and it's going to be as boring as anything. I did think that. I thought it was economics. I mean, who knows? I didn't know anything about economics. But as I got into them, I realised how fascinating each one of them is. I didn't understand all of the depth of it, because when they, if they talk about they do sort of regression analysis, I think, well, that must be right. If they do that, it must be right. They wouldn't have said they'd done it if they hadn't. But the fact is though that you read these articles and each one of them makes you think. So I know most of you here are interested in the economic side of things and the intersection with economics and the law. There are some of these articles actually challenge that intersection rather well, which is good. Catherine, in her editorial, makes a very persuasive case for the reintroduction of economics into the field of law, and she points out quantitative reasoning and empirical research, tools from which lawyers can learn to enrich their understanding of the law. Well, you see, quantitative reasoning and empirical research, it's the empirical part of that, I think, that takes it above other areas like science, because science would say there's quantitative reasoning and research, but not necessarily empirical research. Now, as soon as you start getting into econometrics, I'm lost. And some of the empirical stuff in here I'll come back to is actually quite scary. So I looked through these articles and I thought, which are the one? Catherine was very clever. She wrote in a covering letter, you'll be immediately interested in the one on patents and gender. And I thought, well, yes, but I'll come back into patents is good. And that's one of the ones I'm going to talk about in a bit more detail. But I'll tell you one thing I noticed they all have in common. All the economics and law papers, they all have a colon. Patents and gender, colon, a big data analysis of 15 years of Australian patent applications. Property as emergent order, colon, explanations and limitations, climate and carnism, colon, you see my point. And it's only when you get to the first of the general ones, which is where is the evidence in evidence-based law reform, that somebody has thought of a title that doesn't have a colon in it. So it's very important. Obviously, when you're writing economics and law, you think up a title that is going to have a really good colon. So there are the two that I will talk about in more detail, the ones that you would understand interested me. One is the patents one, and I'm interested in that for a number of reasons. A, patents, and B, gender. C, biological inventions. So they ticked a lot of my boxes, and I will talk about that in more detail. The one that terrified me, absolutely terrified me, was the one on a data-driven approach to evaluating and improving judicial decision-making, statistical analysis of the judicial review of refugee cases in Australia. I thought, expletive deleted. And then I realised it was the Federal Circuit Court, and I thought, thank goodness, because I did a lot of refugee cases and I didn't want to see myself up there on that one. But that raises another really interesting question, because that is one of the... you do see that in the United States. It's the first time I've seen something done like this, which is naming the judges. Actually naming the judges. That was very confronting for me. because it talks in terms of potential biases, which is very interesting. But let me just do a quick canter through some of my interest in some of these ones. So the patents one, as I said, I was a patent girl, and we all know what patents are, don't we? We all know what patents are. Patents are a contract between an inventor and the public. You give us your invention and tell us how to make it, and we'll give you a monopoly. If we make it too hard for you to get that monopoly, why would an inventor give that information to the public? Probably not. That's what a lot of the competition lawyers don't understand. It's all very well to be anti-monopoly, but why would somebody give their invention to the public? You can just have a trade secret, big black box. Don't give it to the public. So you can't make it too hard. But one of the analyses is interesting. But the one on property as emergent order, explanations and limitations. Now that had the first sentence of the abstract, and I did read the whole thing. It says, by dint of our professional training, we lawyers often suffer from legal centrism, the belief that the positive law is the dominant and not the sole source of norms in society. What's wrong with that? Sounded right to me. But of course, the article goes in to explain that that's not right, that there are spontaneous forms of arrangement, that the law can come in and help at the end, but law is not necessarily the beginning and the end of everything. But when it comes to using property as the emergent order, I'm reminded that Anthony Kennedy, who was a Justice of the Supreme Court of the United States, came out and spoke to the Australian Legal Convention once, and he spoke about property, the importance of property in a democracy. And I can tell you at the end of that speech, it had 3,000 delegates of all political persuasions on their feet in a standing ovation. The climate and carnism one was interesting because it's talking about the fact that we all eat meat and the pervasive force of meat eating in Australia and the world, and whether or not that could happen with the current climate emergency. Now, Sir Anthony Mason, in his review, says it's the most important article in the journal. I actually have a bit of an issue with it because for two reasons. First, it talks about, the fact that animals produce methane and that's all the problem, but it doesn't deal with technological change. And at the moment, of course, there are technologies that are being sold, including the use of a seaweed called Asparagopsis, which can reduce methane in cattle by over 90%. So technology, not only in patents, but generally has a place, and that is one aspect of it. The other thing I'm also sitting on at the moment, there are lots of little bits and pieces of things I'm doing, mainly because when I don't know anything, I just say yes, a bit like this, So they ring me up and they say, would you like the government's putting together a review of the Australian carbon credits integrity, the integrity of the Australian carbon credit units. Would you like to be on that? I said, I don't know anything about that. They said, well, that's why we want you. and that's right, you see, because you've got 4 people on that review panel. 2 of them know a lot about it and 2 don't. And actually it's sometimes good to have people who don't know about it because they've got to be convinced and they ask stupid questions, and that's often a good question to ask. So I did look at that, and while the paper mentions the concept of the methodologies used by governments to reduce carbon production by getting people to invest in the offsets like ACCUs. I've just come back from a meeting in the country, and it's interesting to see how much farmers are utilising these to improve the way in which they run their properties, and indeed are able to stay on their properties while at the same time providing carbon offsets. So that's very current. We haven't come to the end of that yet. That's got a report by the end of the year, and it's a fascinating question. So I found that article particularly interesting because it was talking about farming and almost saying, well, maybe we all do want to eat meat, but at the same time, everyone has to do their bit in this climate emergency that we're in order to mitigate it. And of course, that brings up another thing that I did, whether I didn't know anything about it either, was I sat on the Bushfire Royal Commission. And that is another really interesting area of where Australia, the use of Australia's land interacts with a lot of other aspects, not only of climate, but also the future benefit of the country, which was interesting in one way, and the economists are in that as well, but it's also interesting because it really brought in what the Royal Commission was really about was not just the bushfires, but how do the states and the federal government work together to deal with emergencies? And in fact, there was no good basis for that. So that was the first few of the papers. Then I moved on to a discussion about the luxury car tax. Well, I hated that one. Because I think the luxury car tax is a terrible idea as a person who wants to have a luxury car. But Catherine James obviously thought that she was talking about fairness and taxation by redistribution. I sort of looked at that one and I thought, well, this is fascinating. And I read it with a great deal of interest, actually. I thought the logic was compelling, but I remained full of the biases that came up in the next document, in the next one, which was, of course, the judicial review statistical analysis. A fascinating question of whether or not you can just look at statistics to see whether you can see whether there are biases on the part of individual judges. It's interesting. It can be important evidence. You can't draw final conclusions from it, and I'll come back to that. Then we get on to where is evidence and evidence-based law reform. Well, I congratulate the authors for taking on what is almost a sort of a holy grail, which is the Royal Commission into Institutional Responses to Child Sexual Abuse, and dealing with one factor that is important in everything that we do, and bearing in mind that today we know that we hear that there's been a loss of faith in the integrity of institutions, a loss of faith in government, a loss of faith in everything really, and that's part of the problem. And the authors emphasise the importance of transparency. That if you're going to do anything, there's got to be transparency. And that is very much actually comes up with the accuse. You know, the part of the problem with accuse is that a lot of the data has to be kept confidential, so people don't know, and therefore they don't trust. And so it's a really important concept. But also they say that, they point out that lawyers and law students can't be expected to have training in methodology and research synthesis. Well, that sounds right. But also points out another thing about lawyers that is fascinating, that lawyers, and we do it, when you're looking to research something, you're looking for something that will reinforce your position. So we all know as lawyers, if you're reading cases, you're not reading the case to see what that case says. You're skimming through it to find something in there that will support what you want to say, which is absolutely right if you're a lawyer preparing an argument in a case, but not if you're doing an objective analysis that is necessary in order to understand what the correct position is that is going up. I mean, you can only hope in an adversarial world that each side will have searched for the support, and somehow present to the judge something that is value on both sides and does reinforce, gives the judge a proper picture. Because what people don't understand about our adversarial system and the judiciary is that it's not always the first one who gets to win, because often the judge walks onto the bench knowing nothing about the case that you have spent 3 or 4 years of your life working up to do that presentation, and you listen to the first side and you go, absolutely yes, I get that, makes perfect sense, and I agree with it. And then you listen to the other side and you go, well, that makes sense too. And so you really do have to listen to both sides and weigh it up. And sometimes when you come out of court and you think, well, I know which way I'm going to go. I'm going to go this way. And then you go through the discipline of writing, and it won't write. You think it's going to write this way, and it doesn't. It writes the other way. And that has happened on a number of occasions. So having evidence-based evidence, having proper evidence going up, and the logic of that is really important, and it's important to present cases that way. So this is all good. I mean, the heart transplantation case raised a really interesting question for me, which is talking about when do people die and when can you take the heart out. That's a really good question. And it points out you can't say that everything's dead when you take the heart out. I'm being very simplistic, because you put the heart in another body and it works. So when do you make this decision when you've got to take out a heart that's going to have to continue working and yet not take it away from the person before they've died? So it's a very, very interesting article, and I commend it to you. The encryption and privilege against self-incrimination what happens when a suspect refuses to divulge a password? And now this is angels dancing on heads of pins, but it's really interesting because there's a real issue about, the knowledge of the password and the knowledge of the material that the password decodes when you put it in, when you actually enter it. And that it's a distinction that's drawn very carefully and very well. And then you've got to consider about, privilege against self-incrimination. The zoonotic disease issue is scary because it just says the more we're doing all this work about pushing animals together in order to produce more feed from them, is also really dangerous to us, and we're not doing it well enough. And that is that's something that raises an issue that I'd never thought about, and it's worth thinking about. Then we get the command responsibility in Australian military law. That brings up not only command responsibility and, whether the person at the top is responsible for the person at the bottom when they do something wrong, but the idea of where the criminal law sits now is really important, and not just because this article discusses the importance of maintaining the standards of the criminal law in a criminal case rather than a civil case, which involves command responsibility. But think about it today, and I'm not going to go through any examples, but there are examples where with social media and with popular positions being taken, are we risking the end of the criminal law in our society and the protection that provides, presumed innocent until proven guilty? It's part of the rule of law, and it's being undermined, I think, and I think reading that article will help you. And then we get to the director's duty of care in China, which is a very honest appraisal of what is happening. And it's very difficult for China because I've spent a lot of time in China with the judges in China, including when they first took in our competition law. And they took it completely, basically, to the extent that when I went to China and talked to the judges, I came back and I spoke to Russell Miller and I said, I need a lot of copies of your book to send to China because the judges don't have it and they need it. And so he gave me all the whole pile of previous editions, last year's, and we put them in a box, and the federal court put them in a box, and we sent them over to academics and judges in China so they could have the annotated act, because their act's basically the same as ours. But what this article points out is what China did at that time, and one of the judges at the time was telling me they went round the world trying to get the best system they could find in every aspect and import it to China. But that also meant that they were bringing common law aspects into a civil law country. And this article deals with some of those facts and some of those issues, which is really interesting. But let's get back for a second to the patent one. The patent one, it's a very important, this is the love of my life, patents. It's a very important one because why? What does it do? It takes all those years and works out whether there is a gender bias in patents, whether or not women have a harder time getting patents up than men. Now, they deal with a lot of variables. They try and look at all the different variables. How many women are in it? What's the field? Is it the bias by the examiners? Is it different in Australia and the United States? All of these issues, they don't actually deal with how good the person is who writes the patent, but that's okay. That's one variable they missed. That's in my head. But they did find that there is this gender difference. Whether or not, but in the end, what a lot of it comes down to is not necessarily biased by the examiners. What the conclusion comes down to, as I read it in one way, is that some of it is because women have, what they're really saying is that women have different characteristics to men in the way they do it. Is it that women don't give instructions to pursue it, to fight against that questioning harder? Is it because they're more prepared to say, oh, well, I didn't get through? It's also because, and I think it's right, the more women go into the biological sciences, and the biological sciences are the ones that are harder to get patents in. It's easier to get a patent for putting a new turn on a screw than it is to win and do something that wins the Nobel Prize in biology. It's about as bad as that. And as the authors point out, it's made even harder by a new amendment to the Patents Act that's bringing an object clause that emphasises technological innovation, which could be construed to be more physics and mechanics and less biological. And some of that is, and one of the things we're dealing with at the next International Patent Judges meeting are questions of public policy and patent law, which this is part of. There is a huge push, and COVID made it clear, what do you do with patents to things that are as important as a vaccine for COVID? To what extent does public policy come into some of these questions when you've got a statutory right? And it's meant to be objective, but at the same time, it's really difficult because these pharmaceutical companies spend hundreds and hundreds of millions of dollars in research, and then as soon as they come up with a fantastic vaccine, everyone says, well, you've got to give it away for free. And so you've got a huge balance there, and that's really hard. And it's even worse, according to this article, if it's the women who are doing the inventing, because for various reasons, including probably more in the United States, I think they conclude in Australia, there is a bias. Maybe it's an unconscious bias, but a bias against women. And it's unconscious bias that takes us to the last one I'm going to talk about in a bit more detail, which is the scary one about the judges. It is actually quite scary. It's very confronting for me as a judge to read this. Really confronting. Confronting that it's been done and confronting as to where the conclusions come from it. Because they apply statistical analysis to find a large degree of variation in the success rates across individual judges. They took into account, by what they called innovative use of computational methods, a variety of factors. So they did allow for things like caseloads, time to issue judgment, the role of legal representation, the registry, and the gender of the judge. Now, they say their approach overcomes concerns about cherry picking and lack of analytical rigour, and I think that must be right, because when you look at it, they've taken all these things into account, and who am I to do anything like criticise the statistical analysis? I can't, because I haven't got the skill set to do it. So I'm taking it on its face value. So they take judges who heard more than 50 cases and listed them by name in order of success. And the success rate for refugee applicants went from 23% to 0.6. That's a big range. Two of the judges with the lowest success rate, though, were the fastest to judgment and used ex-temp judges. Now, one hears justice delayed is justice denied. That's possibly not the case in refugee cases. But there's this difficulty, this tension for those of you who are going to become judges in the end, and I hope some of you are going to become judges associates. There is this tension when a huge caseload comes up. Do you reserve and take time? And the more time you take, according to this article, the more likely the applicant's going to succeed. Or do you do an ex-temp when you've got everything fresh in your head, in which case, according to this, the applicant's less likely to succeed. So the tension is really quite palpable, and I'm not sure there's an answer to it, but it's a very, very interesting analysis. But then they also examine what they say that can be drawn from statistics, and they talk about cognitive and social biases. And then they make a point that's really hard to cover with, because they say one of the problems is you don't necessarily know that you're biased. You may think you're not biased. You might be sure you're not biased. You might be trying to be as objective as you can, but really and truly you are. Now, it's very hard to come back at that, because, everyone goes in to make these decisions trying to be as objective as possible, and yet maybe you're not. So, as you can see, each of these articles, even if they're not areas that you think you're interested in or have knowledge about, you can read them and draw something from them. I did. I went into these, and they're disparate. They're very disparate in their content, but I went into each of them, and out of each of these articles, I came away with something to think about, something more, and that's why it's good. So coming back to it, do I now feel that I could go and pass an economics exam? Probably not. Might. Depends on the exam. Depends on the bias of the person, I suppose, who is going to mark my exam paper. But do I feel that there's a lot to be seen in that? Yes. Do I admire the people who've written each and every one of these articles? Absolutely, because the work involved and the detail and the rigour is fantastic. Would I love to chat with them and have criticisms about some of, not criticisms, I wouldn't criticise. Would I like to ask further questions? Would I like to cross-examine them a little bit? Absolutely. Because for every side, there is always another side. For every conclusion, there is always another one. And the trouble for a judge is that you get experts who come up and they each are absolutely convinced they're right. They're not necessarily lying. They might actually have different views, genuinely different views, and you as the judge, who is not an expert in that field, is left in the very difficult position of having to go away, not in an ex-temp judgment, Go away and think and try and work out which of these to take. So for those of you who want to litigate, don't. For those of you who want to advise your clients to settle if you possibly can, do. If you can mediate a case out, do, because don't forget, most cases are not won 100 to nothing. They're won 50.5 to 49.5. And it's amazing how one answer in a witness box, one expert, one economist who concedes that there might be another argument and that he or she might be wrong, can lose you the case. So while I think it's wonderful that people go to court, and of course it's, and being a barrister is one of the best things you can be in the whole world, and with apologies to King Wood Mallesons, who I still call Mallesons Stephen Jace because I'm so old. Just bear that in mind, because this is the stuff of expert evidence, this is the stuff of two minds may differ, and someone's going to have to make that decision. And you know something? I'm glad that I'm no longer on the court and it's no longer going to be me. I would like to thank you. By the way, I must share with you, though, one other way in which science and the law do coincide. I did my PhD thesis on phospholipids in sperm. And I worked on 8 different species of sperm, including human. And so there is a wonderful way and that was a very interesting, it was about membranes, membranes, very interesting. I can give you a long talk on that, but I won't. But Michael Kirby once came up with a lovely comment that made me realise how 2 different areas can come together. And he said, what do lawyers and sperm have in common? And the answer was they each have 1 10 million chance of turning into a real human being. I'd like to congratulate everybody involved in this. It is a tour de force.
Good evening. My name is Wei Huan Zhou. I'm Associate Professor and Director of Research at the UNSW Law and Justice Faculty. It is very difficult for me to speak after Dr. Bennett, and also I don't really have that fantastic motivator to conclude my speech today. But I hope that I can do my best to thank everyone involved in this fantastic event. I would also like to start by acknowledging the traditional custodians of the lands on which we meet today, and pay my respects to the elders past and present. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. My first thanks goes to Dr. Bennett for extremely insightful, amusing, and thought-provoking keynote speech. Dr. Bennett's outstanding experience and achievements in the legal profession as an eminent and influential judge, lawyer, and now I think in many ways legal and policy advisors, domestically and internationally, makes her a perfect commentator on the topics relating to the nexus between law and economics. I don't want to spend too much time commenting on Dr. Bennett's insightful speech on the details of the articles and the journal, of the issue of the journal, but 2 basic knowledge takeaways from her speech. The first was really just a reminder of when I was doing my PhD thesis. I was in the field of international trade law and dealing with what we call the non-discrimination principles. I'm trying to use economic theories for that purpose. And I can still remember for about 2 months at night in 2009, I wasn't that young, in 2009, I tried to figure out why trade is good, what is partial equilibrium, what is general equilibrium, and what is the Nash equilibrium. So I was kind of smashed into this kind of equilibrium models, economic models, and trying to figure out why we need trade and why trade does good for economies and for people. And And I was still at the age at the time that I was most efficient at night. And then I did gym and I went back home and said, okay, 8 p.m. Now let's read some economics. I had about 20 books there and trying to just figure out the basic concepts. I know nothing about it at the time. I fell asleep every night. It's not because of it's boring. I was very excited about it, but just because I don't really understand it. It took me about 2.5 months to understand the basic concepts. And then it took me about 2.5 years afterwards to figure out how economics can actually inform legal thinking and also inform lawmaking at the international level in my field, but also judicial decisions. And the second takeaway, I was asking Dr. Bennett about what's the message, the key message. Can you give me some tips? Because I want to just learn from it before I make my thank you notes. At a very broad level, the takeaway for myself was really just fantastic. I think many students are here today as well. The first tip is that every knowledge learned in your life won't be wasted. I think that's very important. And secondly, be curious about new challenges and areas that you don't know about. And if you combine both of the two tips, and then you will have a chance to learn more about the nexus between economics and law. So that's really just a brief takeaway from Dr. Bennett's fantastic keynote speech. My next thanks goes to the authors for their great contributions to this issue and to the scholarship. There is no need for me to go through the articles anymore because Dr. Bennett has already given you a very detailed rundown of the main message from each of the articles. I just want to say and also confess that many of the topics are not within my areas of expertise. But what I did find very interesting and impressive is the innovative methods used in these articles to connect law and economics, or the ways to use economic approaches to addressing legal issues, the major ones that we face today. I have no doubt that these contributions would advance knowledge and drive academic policy and public debates in the long run, in the different areas of law and practices. And so please take a copy if you're interested in these topics. And you may also go to the UNSW Law Journal website. And I believe that the articles are being uploaded gradually. Next, our thanks on behalf of the faculty must also go to our hosts tonight, King Wood Mallesons. King and Wood Mallesons is the premier sponsor of UNSW Law Journal and has been a sponsor for 4 decades, over 4 decades. So your sponsorship and support is really highly appreciated, just as how much we value the relationship between our two institutions. I would be remiss if I don't also acknowledge the generous support that King and Wood Mallesons has provided to UNSW Law and Justice more broadly. For example, since 2013, King Wood Mallesons has generously supported the research of Professor Ross Barkley in financial and technology law. Apart from research, King and Wood Mallesons has also been highly generous and supportive in our education, providing opportunities for our students, many of our students now, to advance their practical knowledge and skills in various ways, and in that way, greatly contributed to our education of lawyers of the future. So again, thanks for your preeminent and continuous support for research and education at UNSW Law and Justice. Finally, and very importantly, on behalf of the faculty, I would like to thank our student editors for hard and fantastic work to produce another very high quality issue. Your commitment to the journal is essential for its unstoppable, in my view, success and sustained impact domestically and globally. And in particular, let me thank Catherine Chen, an editor of the issue 45.3 of UNSW Law Journal, and Darius D'Acosta, executive editor of the UNSW Law Journal, and the UNSW Law Journal editorial board, and everyone involved in this journey. Thank you so much, and congratulations. So that concludes my remarks. I don't want to stand too much in the way of between me and drinks. Enjoy the rest of the event, and good evening.
Yes, so thank you, Associate Professor Zhou, for that vote of thanks, and thank you, Dr. Bennett, for your insightful keynote address. So with Volume 45, Issue 3 of the UNSW Law Journal officially launched, we have now reached the conclusion of tonight's formal proceedings. Please feel free to remain and mingle for the next hour or so, and please do not forget to collect a complimentary copy of Issue 45.3 if you haven't already. All of the articles in this issue can also be found on the journal's website. So thank you again for your attendance, and I hope that you enjoy the rest of your evening. Thank you.